Independent contractor with employee. My company is a small company that runs Chinese after-school program. I teach them Chinese class and have some other programs also. I need to hire a driver to help me pick up kids from different local school after school. Should I hire them as an employee or independent contractor? First, we need to know what's the difference from independent contractor and employee. Who is independent contractor or employee? Independent contractors and employees are not the same, and it's very important to understand the difference. Knowing the distinction will help you determine what your first hiring mode will be and affect how you withhold a variety of taxes and avoid costly legal consequences. Who is independent contractor? People who are in an independent trade, business, or profession in which they offer their service to the general public are generally independent contractors, such as doctors, dentists, lawyers, accountants, contractors, real estate agent, part organizer, yard helper. However, whether these people are independent contractors or employees depends on the facts in each case. The general rule is that an individual is an independent contractor if the payer has the right to control or direct only the result of the work and not what will be done and how it will be done. The earnings of a person who is working as an independent contractor are subject to employment tax. The general rule that determines whether someone is an employee or an independent contractor is that an individual is an independent contractor if they decide how the work will be done. The company doesn't tell independent contractor what to do and how to do it. What is important is the end result, and how it's reached is up to the contractor. Independent contractors typically set their own hours and are paid on a freelance basis, either a flat rate or per job rate. Independent contractors are responsible for paying their own taxes to the IRS and to their state tax department. Independent contractors are not entitled to benefits, even those mandated by law like unemployment and workers' compensation, because they are not employees of a company. Who is an employee? In most circumstances, an individual is only protected if she or he was an employee at the time of an alleged discrimination rather than an independent contractor, partner, or other non-employee. An employee is an individual employed by an employer. An individual may have more than one employer. The question of whether an employer-employee relationship exists is fact-specific and depends on whether the employer controls the means and the manner of the worker's work performance. This determination requires consideration of all aspects of the worker's relationship with the employer. Factors indicating that a worker is in an employment relationship with an employer include the following. The employer has the right to control when, where, and how the worker performs the job. The work does not require a high level of skills or expertise. The employer furnishes the tools, materials, and equipment. The work is performed on the employer's premises. There is a continuing relationship between the worker and the employer. The employer has the right to assign additional projects to the worker. The employer sets the hour of work and the duration of the job. The worker is paid by the hour, week, or month rather than the agreed cost of performing a particular job. The worker does not hire and pay assistants. The work performed by the worker is part of the regular business of the employer. The employer is in business. The worker is not engaged in his/her own distinct occupation or business. The employer provides the worker with benefits such as insurance, leave, or workers' compensation. The worker is considered an employee of the employer for tax purposes, like the employer withholds federal, state, and social security taxes. The employer can discharge the worker. The worker and the employer believe that they are creating an employer-employee relationship. This list is not exhaustive. Other aspects of the relationship between the parties may affect the determination of whether an employer-employee relationship exists. Furthermore, not all or even a majority of the list criteria need be met. Rather, the determination must be based on all of the circumstances in the relationship between the parties, regardless of whether the parties refer to it as an employee or as an independent contractor relationship. A worker is considered an employee if the employer controls what work will be done and how it will be done. What is important is that the company has the right to control and manage the details of how and when the work is performed. Employees are on the company payroll, and the employer withholds federal and state taxes, Social Security, and Medicare. Employees are provided with unemployment and workers' compensation insurance. Employees may be offered benefits like paid sick leave, vacation, health insurance, or 401k or other retirement plan participation. Under common law rules, anyone who performs services for you is your employee if you can control what will be done and how it will be done. This is so even when you give the employee freedom of action. What matters is that you have the right to control the details of how the services are performed. Second, after we talk about what are employee or independent contractor, we know the idea to hire different people. In order to know the detail, let's compare what's the difference of those two kinds. What's the difference between these two? An independent contractor operates under a business name, has his or her own employees, maintains a separate business checking account, advertises his or her business services, invoices for work completed, has more than one client, has own tools and sets own hours, keeps business records. The agency is more likely to clarify as an independent contractor a worker who can earn a profit or suffer a loss from the activity, furnishes the tools and the materials needed to do the work, is paid by the job, works for more than one company at a time, invests in equipment and facilities, pays his own business and traveling expenses, hire and pays assistants, and sets his or her own working hours. An employee performs duties dictated or controlled by others, is given training for work to be done, works for only one employer. On the other hand, the RRS is more likely to clarify as an employee a worker who can be fired at any time, is paid by the hour, receives instructions from the company, receives training from the company, works full-time for the company, receives employee benefits, has the right to quit without incurring liability, and provides services that are integral part of the company's day-to-day operations. After we learn the difference between these two, let's figure out who should I hire. Why should you hire independent contractor or employee? Why does it matter? If the RRS would consider the worker an independent contractor, your company does not have to withdraw federal payroll taxes as you would for an employee, including Social Security taxes, federal disability taxes, and federal income taxes. Misclarification of an individual as an independent contractor may have a number of costly legal consequences. Many small companies rely on independent contractors for their staffing needs. There are many benefits to using contractors over hiring employees. Saving in labor costs, reduced liability, flexibility in hiring and firing. In an effort to cut costs, employers are increasing clarify workers improperly as independent contractors. This clarification can deny workers minimum wages, overtime, compensations, retirement, and/or healthy benefits, FICA taxes, workers' compensation, unemployment, and other benefits. Things that I should know. Though I think it's good to hire an independent contractor, it's the best choice for me, but I have to know about these things. If your independent contractor is discovered to meet the legal definition of an employee, you may be required to reimburse them for wages you should have paid them under the Fair Labor Standards Act, including overtime and a minimum wage. Pay back taxes and penalties for federal and state income taxes, Social Security, Medicare, and unemployment. Pay any misclarified injured employee workers compensation benefits. Provide employee benefits, including health insurance, retirement. Conclusion. To me, I have a very small business. Compare all those above, I think it should be better for me to hire an independent contractor. I think my situation meets the requirements of an independent contractor. For example, my driver will provide his or her own car to drive the kids. and he can hire somebody help him to gather the case together or to help him drive. What's important to me is to drop the case to my school. I only care about the result, not how they reach it. They can have more clients, like they can help other after-school picking up case too. Doesn't matter as long as they drop off the case to go to my school. Also, I don't need them to come to my company any other time. Of course, because the cost cuts is very important to my small company, hire an independent contractor will cost me less money. I don't need to pay minimum wages, overtime, compensation, retirement, and or health benefits, FIC taxes, workers' compensation, unemployment, and other benefits. And I have less liability. Also, I have less ability to hire another person. Compare all above. I would like to hire an independent contractor for my company.